me introduce myself. I'm Attorney General Bill Sorrell, and very happy to see the group that's gathered here today. This is the third of three sort of public information sessions that we've had this week. We started Monday or Tuesday, beginning of the week up in Burlington, and then we had an evening, that was midday, then we had an evening session Wednesday in Montpelier, and today here. And this is an information exchange as part of the rulemaking process that the legislature in its GMO or GE labeling law authorized us to conduct. And the idea is, and we see it in other kinds of statutes, is that rulemaking regulations or rules are intended to sort of give more substance to the skeleton of a statute. And so right in the GE labeling law, the Attorney General was authorized to do this, and it's to sort of fill in different areas and give more substance to the law and guidance to those who need abide by the dictates of the law. We started working on the rulemaking literally as soon as the bill was passed in the legislature, and even before being signed by the governor. The reason being that with the July 1 of 2016 effective date of the statute, we wanted to get through the rulemaking as expeditiously as possible, hopefully with an eye towards the rule being in final form roughly July 1 of next year, or approximately a year before the effective date of the statute, so that those who are bound by the statute have plenty of time to know in very real detail what their obligations are. We started in the spring with just sort of generally seeking comment from manufacturers, grocers, farmers, average citizens on what areas we should be focusing on in the rulemaking process. We've taken that input and then our own research and talking to experts, and we've put together this draft rule that we put out publicly last week, and it's the subject of these gatherings this week. This is not the formal rule that we will be presenting to the legislature for its approval. Rather, this is hopefully the next to last proposed rule, and the purpose of these gatherings this week is for us to explain a little bit the basics of the law, but then talk about some of the issues that we have put forward in the rule. And then there will be opportunities for you to ask questions of us and try to get answers to you. And if you have comments that you want to make after the question period, we'll accept comments, but we'll have a slide up which will give you information that if you want to register comments or pose further questions after this proceeding today, that you'll be able to do so. And just looking forward a little bit, we hope to have the rule in proposed final form right about the first of the year, and again, looking for adoption, final adoption, right? And after we put it out in final form, then there will be other public hearings, formal comment period, and looking for ultimate adoption, as I said, right around the 1st of July. Let me introduce the other members of the team who are here. who have been working on the rulemaking. And let me start with Wendy Morgan, who is the chief of our Public Protection Division in the Attorney General's office. And among the units in the Public Protection Division is Consumer Protection. And to Wendy's left, we have a woman who's been helping us through this process. She's in the graduate program in food systems at the University of Vermont, Christina Sweet. And then the star of the show for us today is Assistant Attorney General Todd Daloz, and he's the one who's going to be doing the lion's share of the talking for us. As you are no doubt aware, we've been sued in federal court by the national grocery manufacturers and some other plaintiffs, and we have a team in the office working of several assistant AGs working essentially full-time on the lawsuit. This is a separate track, and we've got these folks and a few others working on the rulemaking. There is some cross-pollination, but we've got plenty to do. And on in the litigation itself, which is pending in the federal district court up in Burlington, we have also hired outside counsel to assist us, a law firm out of New York with a great deal of experience in federal court litigation. So we had a lot of folks dedicated to the effort, but really what this is today is for you to hear from us and perhaps understand some things better, and particularly for us to hear from you. So I'm going to stop talking and turn it over to Todd Daloz.
Thank you, Attorney General. Folks, thank you for coming. I just want to start by saying that I feel like you're taking time out of your busy days to be here, and we certainly appreciate it. We appreciate the input that hopefully you'll provide, the comments, etc. I'm going to talk for about 30 minutes. If there are specific questions, if you don't understand something on a slide, feel free to stop me and just ask a question. But if there are more general questions about what the rule means in this context, or have we thought about that, or how did we come up with this decision, it's easiest, I have found, to save those for the very end of the presentation. We can kind of take all the questions as they come. Does that sound good? All right, so I like this size because I feel like we can actually communicate a little bit. So we talked a little bit about the purposes of the meeting, but obviously it's presenting the labeling law, and I just want to be clear about something. So the legislature passed Act 120. That's the statute that requires the labeling of food produced with genetic engineering. After we talk about that statute, because it's important to understand what the legislature said, we're going to talk about what the Attorney General is proposing as a means of putting meat on the bone, right? As a means of kind of fleshing out what those requirements of the legislature means. And then, obviously, it's a chance to provide input. It's not an opportunity to really hash out compliance. I make X and I want to do Y, and how do we make that work? So I just wanted to be clear about that.
And I should have said, excuse me, Todd, today's gathering is not an opportunity for those who are critical of the law, don't think the law should have been passed. The law has passed the legislature, it's been signed by the governor. If the law is going to be changed, assuming that it's upheld by the federal court, it's going to be backed by the legislature. But if we had, particularly Monday, some folks who wanted to complain about the law, and you're absolutely entitled to be critical of the law if you wish and put in your input afterwards on that, but quite frankly, it wouldn't be productive for us today to be entertaining objections to the statute itself. Objections to the proposed rule, we do want to hear that today.
Absolutely, and I think part of the way we're setting up the presentation is to help you out understanding that, what the statute says and then what the rules say. Before we get to the statute, I want to talk about a couple different things. The first is a very simple, what foods are genetically engineered at this point? And And this is not, meant to provide you a scientific basis for this, but really to give you a better sense of the kinds of foods we are talking about. The first major category are mostly component parts, but these are the ones that are most available to consumers. So field corn, which becomes corn syrup, cornmeal, lots of different ingredients that are grown out of corn. Soybeans, likewise. Sugar beets, which is a lot of the sugar currently being used. Canola, cottonseed oil, and also alfalfa. There are fewer available ingredients that are available direct to consumers as produce. There's a variety of papaya, there are a few varieties of sweet corn, some summer squash, and at one point in time there was a variety of tomato that actually is no longer available to consumers. That's preliminary point one. Preliminary point two, and the Attorney General talked about this, so I'll go very quickly. Quick civics lesson. I feel like civics is underappreciated, so I wanted to talk about it. And you have to listen to me, right? So, Act 120 establishes the opportunity for the Attorney General to make the rules. The rules then fill in the gray areas of the statute, and I'll highlight some of the gray areas as we go through the statute. I'll highlight the gray areas that we really focus on in rulemaking. There are rules out there already that you probably live under, you definitely live under, and you probably know about. The health code, the tax code, environmental codes. You put those together, the statute and the rule, that's what we really call the law. So we got through our civics. We're going to talk about Act 120. The first thing to talk about is the purpose of Act 120. So why did Act 120 get enacted into law? There were four main purposes that the legislature wanted to focus on in passing Act 120. There were concerns about public health. There were concerns about the environmental impacts of genetically engineered foods. There were religious concerns that were raised about genetically engineered foods. And there was a concern about consumer deception, and that was specifically focused on the use of the term natural in describing foods that contained genetically engineered ingredients. There was also a lack of federal regulation, any regulation at the federal level. So, Act 120 does two main things. First, it requires the labeling of food produced with genetic engineering if it's offered for retail sale in the state of Vermont. From that broad category of food, there are some exemptions we're going to talk about. And finally, it prohibits the use of the term natural to describe those foods. That's the broad overview. Before we get into a little bit more of a detailed walk through Act 120, I want to talk about two key terms. The first is food. This is a tricky one. It's sort of funny, but you think food, I know what food is, but food is actually a difficult legal term to define, and that's why it is a little self-referential. And so in some ways it's helpful to talk about what food is by way of example. We could all imagine that a hot dog, of course, is food, a can of corn, but in fact the definition of food includes chewing gum. Why, that's kind of funny, but I'll give you just a very quick history lesson on that. When the original federal drug, the FDA Act was passed, they included chewing gum. It was sort of a novel food at the time, but the whole point was to say, look, that's the outer edge of food. We can all recognize that a loaf of bread is food, but chewing gum is too. So that helps us understand the universe of what is food. The law, though, and specifically the rule, the draft rule, suggests that food is not going to include dietary supplements, it's not going to include drugs, which are separate types of consumables, but were not what the legislature appeared to intend when it talked about food. A little bit more on food. The way that the Act defines food is broadly into two categories. The first category is raw agricultural commodities. That's produce. You recognize it. I swung through the co-op just earlier today. You can see it on the shelves, in the bins, laid out. The second type is processed foods. In some ways, it's easiest to understand this as everything else, because if we think about processed foods, we may think about a much higher level of processing than what the law actually considers processed. So even if the corn is just shucked, that corn is processed. If the banana is peeled, it's processed. If the melon is sliced up, that's processed. It also means if the grain is ground into flour, that's processed, if it's baked, etc. So the other key term, that was food, and now we're going to talk about GE, genetically engineered. There's a long definition up there about what is genetically engineered, but what I really want to highlight is genetic engineering is a process in which genetic material from one organism is combined with genetic material from another organism in a manner that overcomes otherwise existing natural barriers, recombinant barriers, reproductive barriers, physiological barriers. So there are lots of examples of of human intervention in the reproductive process of plants and animals that have occurred over time that do not overcome those natural existent barriers to enable genetic material from organisms of different groups to be put together. Traditional breeding techniques, conjugation, fermentation, traditional hybridization, in vitro fertilization, tissue culture. These are kinds that exist in laboratories, but do not take that extra leap of putting genetic material from one organism of a taxonomic group together with material from another in a manner that overcomes those natural barriers. Those are the key terms. So let's talk about what Act 120 requires. Again, first and foremost, it's labeling. It requires the labeling of raw agricultural commodities. It requires that labeling to be clear and conspicuous. It has to say produced with genetic engineering, that phrase, if the raw agricultural commodity is unpackaged. It has to be, this disclosure has to be placed on the shelf or bin. And the retailer who is selling that good is responsible for that label. If it's a separately packaged item, raw agricultural commodity, the disclosure has to be printed clearly and conspicuously on the package, and the manufacturer is responsible for labeling. That's raw agricultural commodities as Act 120 requires the labeling. Second category of food. So we did raw agricultural commodities. Let's talk about processed foods. This is most of the food. It's got to be one of three labels. It can say produced with genetic engineering, it can say partially produced with genetic engineering, or it can say may be produced with genetic engineering. Those are the three options. And it's got to be, manufacturer has to label it on the package. Those are the requirements under Act 120. But there's one area of food that isn't included in here, and that's processed foods that aren't separately packaged. So that's the bulk section of a supermarket. That might be deli foods, that might be bakery foods. There are some exemptions that come into play with those, but it's important to recognize that there is this other area that's important to discuss. That's the labeling requirement. It's actually pretty simple. Now we're going to talk briefly about the exemptions and exceptions of Act 120. These are three general categories. I'm just going to talk quickly about a couple of these. So the first general type of exemption is food with no or minimal genetically engineered content. So the first is animal products. So that's anything that is 100% an animal or 100% derived from an animal. So that's really meat, milk, eggs. The second is enzymes and processing agents. These are things that are added to food for a functional result, but don't actually change the nutritional content of the food. Cheese rennet that's added to cheese is a good example of this. Finally, the legislature drew a threshold that said if the total amount of GM material in a product is less than 0.9%, that product doesn't have to be labeled either. It's such a low threshold that it doesn't have to be labeled. Another area of exemptions is the heavily regulated exemptions. So the first of these is alcoholic beverages, which are regulated under Title VII of the Vermont statutes. The second is medical food. And when I say medical food, this doesn't mean food served in a hospital. It doesn't mean Ensure or Boost shakes, things like that. These are actual foods that are produced in specific facilities and are medically prescribed. So you know medical food if you eat medical food, and if you don't know medical food, then you're not eating it. There are a couple additional exemptions. I'm going to talk about them really quickly because we're going to discuss them in more detail when we talk about the rule. The first is food prepared and intended for immediate human consumption. So this is mostly restaurant kind of food. The second is food for which the retailer has a sworn statement affirming that the food was not knowingly or intentionally produced with genetic engineering. And the third is food that a third party has verified as not containing GE. We'll talk about those when we get to rulemaking. So we've talked about the labeling, we've talked about the exemptions, and now I want to talk about the prohibition. So Act 120 prohibits the use of the terms natural, naturally made, all natural, naturally grown, or any words of similar import that would have a tendency to mislead a consumer. And it prohibits the use of them on the package, on the sign, or in advertising. So that's the line that Act 120 draws, and that prohibition extends to the same foods that require labeling. Which is another way of saying the exemption that applies to labeling also applies to the prohibition. Okay? So one last little piece, and I just put this in there because I'm not sure who's in the audience, but I think it's important to understand that retailers are not liable for labeling packaged food. And a retailer is not liable for labeling unpackaged produce if they can obtain the sworn statement or can correct their failure to label within 30 days. So that's in Act 120 as well. Basically, it enables a retailer to fix a problem if it's pointed out to them. It is important, though, to just highlight that a retailer isn't a retailer if they've manufactured the food. So if the retailer takes the melon and cuts it up, they've processed that food, they are the manufacturer, they would not be able to be protected by this limitation of liability. That's Act 120. We're good? Makes sense? All right. Let's talk about the rule. And again, I'm going to highlight the areas where the proposed rule is adding some definition to terms that need a little bit further expansion. But these are areas where we're looking for input. First and foremost, as we set out on this task, we wanted to implement the legislative intent. So there are those four purposes I talked about up front: public health concerns, the religious concerns, the environmental concerns, and the consumer deception concern. Those boil down on some level to a need to provide accurate information to a consumer at the point in time that they're making a decision to purchase. The second major thing we wanted to focus on is minimizing the burden on the regulated community. The food system is an incredibly complex web of regulation, of contractual obligation, of logistics. And our goal in doing this was to say we've got the legislative intent and we've got a community that needs to be able to comply with this in a manner that makes sense. So we want to hear from that community, and we want to do this in a way that works for that community. Ultimately, it's addressing practical concerns on the ground. Finally, it's about providing clarity on the scope and reach of Act 120. So, in implementing Act 120, these are the main issues we looked at that felt like needed further explanation. Obviously, the actual details on where to put the labels, as you can see some of these examples up here, we'll look at those in a minute. That was one. How to deal, as I said, with unpackaged processed foods as a category of food that was not entirely clear from Act 120, how to treat that. Defining the scope of certain exemptions under the law, and exactly what the bounds of the natural prohibition were. So, as I said, there are two main types of food laid out in Act 120. Raw agricultural commodities and processed foods. They can also be divided between unpackaged foods and packaged foods. So there are really 4 kinds of food to talk about, and I want to talk through each one individually. Unpackaged raw agricultural commodities, unpackaged processed foods, packaged raw agricultural commodities, and packaged processed foods. Okay? It's still straightforward. So the first one's first, produce. Unpackaged raw agricultural commodities. So Act 120 said for raw produce, it's got to say produced with genetic engineering, it's got to be clear and conspicuous, the retailer is responsible for labeling. And what the proposed rule suggests is that that label has to be on each sign. So that's any sign that identifies the product and or the product price. So if you imagine yourself in the store, there's got to be a sign that says sweet corn, and on it, clearly and conspicuously, it says produced with genetic engineering. If there was another sign up above this bin that said sweet corn, that would also have to say produced with genetic engineering. There's a quiz. What's wrong with this picture?
It's only on one.
It's shucked, so it's shucked.
It's shucked. This is actually a processed food. It was the best picture we could get, so it made the most sense. But that just also highlights how minimal processing can be. I will say the sign is still accurate. For a processed, unpackaged food, this is exactly how it would be labeled. So let's talk about that. Unpackaged processed foods. Again, this is bulk foods. This is possibly deli, bakery items. And so none of this was laid out in Act 120. So what we did was we drew from how the legislature wanted unpackaged raw ag commodities to be labeled and how the legislature wanted processed foods to be labeled, and we put it all together. So the disclosure has to be clear and conspicuous. It's a processed food, so it can be one of the 3 labels. Produced with genetic engineering, partially produced with genetic engineering, maybe produced with genetic engineering. And it has to be somewhere on the shelf or bin where the item is displayed for sale. So if you're looking at the bulk section, we've got multiple bulk items, and then here we have a sign directly on the container that says produced with genetic engineering. I should have said this at the beginning. We talked about what foods are out there that are available that are produced with genetic engineering. Lentils is not one of them. And I may use other examples throughout for ease of understanding where the actual food may not be produced with may not be available in a genetically engineered variety. Just bear with me for the sake of example. But this is a good illustration of what a bulk food labeling might look like. So I want to stop right there and talk about unpackaged labeling. Who labels the unpackaged foods? The retailer labels the unpackaged foods. Makes sense. They're the ones who are displaying the foods. They have the direct connection with what foods are being displayed in an unpackaged form. Hard to imagine how a manufacturer would label an unpackaged food. Who is a retailer? So a retailer offers food for retail sale to the public in Vermont. It includes producers who sell directly to the public. So if I have a farm stand, sell on the side of the road, I go to the farmer's market, or I run a CSA, I am the producer of that food, unquestionably, but I am also the retailer of that food. So I'm still responsible here. Does that make sense? Okay. Let's go on to type number 3. It's a small kind of food. Packaged raw agricultural commodities. Again, it's important to remember that a raw agricultural commodity is in its natural form. So even if the food is sliced or the corn is shucked, that becomes a processed food and it falls in a different category once it's packaged. Packaged raw agricultural commodities have to say produced with genetic engineering on them. It has to be clear and conspicuous. It has to be on the product label, and the manufacturer has to label it. But it's a little tricky where you draw the line between packaged and unpackaged. So the definition that is proposed in the rule is that raw produce that is more than 1/3 covered or wrapped and has the manufacturer identified on that wrapping, that's packaged and the manufacturer has to label. I see you all get it, so I'll just give you some quick examples. A mesh bag of onions. That's a packaged food. a rubber band around some broccoli. That's not a packaged food. A paper bag of apples, packaged. A plastic slip cover over some lettuce, packaged. A sticker on some bananas, not packaged. So that's the line that is in the proposed rule. The final category is packaged processed foods. This is everywhere else in the supermarket. This is a lot of other food. There are 3 labels that are available: produced with genetic engineering, partially produced with genetic engineering, maybe produced with genetic engineering. We'll talk about the distinctions among those 3 in a minute. Here's what the draft rule proposes. That the labeling, whichever one of the 3 is used, that the manufacturer uses, has to be easily found on the package. What does easily found mean? Well, the suggestion is that that information is easily found if it is on the same panel, the information panel, that already has the nutrition facts label box and or the ingredients. A manufacturer could put it somewhere else, but they run the risk of it not being easily found, and therefore they have not properly labeled. It also has to be easily read, which means in the same font size or larger of the serving size listing in the nutrition facts label. Why that? Well, if we were to mandate a certain font size and you sold a chocolate bar that was 1 inch by 1 inch, you could imagine that disclosure wrapping all the way around, whereas if you sold a box of cereal, you can imagine not seeing that disclosure at all. Manufacturers have to make the calculation under federal law for what size serving size is listed as. So it's already a calculation they're making. They already understand the size that it needs to be printed in. This disclosure would just have to be printed in the same size font. So it looks like this. Produced with genetic engineering. This is an example, right, of maybe a box of cereal or something like that. Because we couldn't actually take a box of cereal that's copywritten, there are some other concerns around using a real item. There's no ingredients listed here, so you can imagine that the ingredients list would go in here, and then we'd have the disclosure right under it. Likewise, on a canned good, again, you can see it says serving size up here, and in the same font, it says produced with genetic engineering. So that's what a processed food would look like with the proper disclosure. Again, with packaged foods. Oh, sorry, before we get to exactly what I was going to say. There are 3 kinds of labels. We've talked about them a bunch. Produced with, partially produced with, maybe produced with. So what do these mean? The rule proposes that for partially produced with genetic engineering, it means it may be used only when the food contains less than 75% GE content. So if it's more than 75%, it just says produced with genetic engineering. If it's less than 75%, it can say partially produced. Why 75%? Well, there are a couple reasons, but generally 90% doesn't seem like partially. But 50% may seem less than partially. And the organic standards as they currently apply have a 3-tiered system as well, and 75% is their mid-range on whether you can label something organic. Seems to be a safe number, but absolutely an area we're interested in hearing input on. How is maybe defined? Maybe can be used when the manufacturer does not know whether the food contains food produced with genetic engineering. To know is a tricky one. It's another one. It's like food. It's got a tricky definition, even though we feel like we understand it. It requires some effort by the manufacturer. A manufacturer can't just cover their ears and say, I don't know. They have to have some effort in attempting to find out. So, packaged foods, who labels them? The manufacturer labels them. Who are manufacturers? Well, the manufacturer is the person who produces a processed food or raw agricultural commodity. So that can be, it's very broad under the law, and this is actually from Act 120, not the rule. It can be the importer, it can be a farmer, it can be somebody who just puts a store brand on something, it can be somebody who sells their brand to somebody else to put it on their food, it can be somebody who has hired a co-packer to produce and label and sell something with somebody else's ingredients and name on it. And it can also be somebody who buys somebody's label and puts it on their food. It's a lot of different things. It covers a broad swath of the food system. So the bottom line with this is, generally speaking, a person who labels a food is responsible for providing the disclosure. For packaged foods, that means it's the manufacturer. For unpackaged foods, that generally means it's the retailer. That's how the rule examines labeling. So let's talk about exemptions. Again, there were the exemptions laid out in Act 120, and I really just want to focus on a couple under the rule that are somewhat different. The first is that food prepared and intended for immediate human consumption. Again, this was a term that the legislature seemed to intend to cover restaurant foods, foods that we go out and buy and eat immediately, right? Prepared and intended. Well, as it turns out, retailers already make a calculation around that food. They already pay taxes on foods prepared and intended for immediate human consumption. It's called a taxable meal. So this seemed to be a good opportunity to dovetail a calculation they already make, a distinction they already make, with a different requirement. So that means that the food for immediate human consumption is processed food, unpackaged, that is purchased as a taxable meal under Vermont law. It means any unpackaged food sold in a restaurant. And it means any unpackaged food sold in an establishment where more than 50% of the sales are taxable meals. So let me talk about that third category very briefly. The co-op's probably not a good example, but there might be a corner deli, maybe the deli up on Route 9, where they sell both sandwiches, ready to take out food, and some other food items, some of which may be unpackaged. If their total sales of food, more than 50% are from that immediate section, none of the unpackaged food has to be labeled. That's the distinction. Another exemption is heavily regulated food that is regulated by the USDA. So packaged processed food that contains meat or poultry that has to be labeled, that the USDA has to approve the label under federal law, or the state of Vermont, the Agency of Ag, has to approve the label, is also exempt, because it's another area of heavily regulated food. So the last two to talk about are the sworn statements and the verified foods. So these are ways of a retailer or manufacturer proving that their food doesn't have to be labeled. The first is that the manufacturer, wherever they are on the food chain, signs a sworn statement that the food is not knowingly or intentionally produced with genetic engineering. Anywhere up that distribution chain, a manufacturer can rely on the previous seller's statement. What does that mean? Well, let's say I sell bread in my supermarket. I buy it from a baker. The baker signs a sworn statement saying not knowingly or intentionally produced with GE. They rely on the miller who sold them the grain, who in turn relied on the farmer who grew the wheat. It works its way up the chain. Anybody who has it has to keep it for 3 years. The record's retention is 3 years. Similarly, in order to establish that a food is not genetically engineered, you can also rely on the verification of a third party. One such verification is food certified organic by an organization accredited under the National Organic Standards. The second option is food verified as not produced with genetic engineering by another qualified organization, and those organizations apply to the Attorney General, are approved by the Attorney General, and then this is organizations like the Non-GMO Project is sort of the easiest one to think about. They apply to us, and we've developed a rubric that we will release once the rule is officially promulgated by the legislature. But it includes requirements of traceability, testing, segregation, the industry norms here. Talked about the labeling, talked about the exemptions, now we're going to talk quickly about the prohibition and wrap it up. The labeling prohibition, again, applies to the same foods as the labeling requirement. as we looked at what the legislature stated, that manufacturers couldn't use natural, all natural, 100% natural, or words of similar import, we sat down and really thought about it. We're not marketing people, so this is wide open. People have other suggestions. But these are really the three phrases that we came up with to kind of, to typify what the legislature was intending here. That it's really the words nature, natural, or naturally that cannot be used in any statement. Think about words like pure, or traditional, or old-fashioned. Those actually seem to more refer to the cooking process or the creation process as opposed to actually the underlying components of the food. So this is what the draft rule prohibits using. Prohibits it on product labels, it prohibits it on signage, the point of display, and it prohibits it in advertising at the retail premises in Vermont. Because that's the place where somebody who's buying the food is making a decision about purchase. That environment. It does not apply to trade, brand, or product names. The actual name of the product is not prohibited from using those terms. And it doesn't make any requirements or prohibitions regarding the ingredient label, the nutrition facts label, those items that are required by federal law. Along with the prohibition, it's also optional for a manufacturer to make other lawful disclosures, including that the United States Food and Drug Administration doesn't consider food produced with GE to be materially different from other food, or saying that the food is GE free or anything else that's lawful. Manufacturers are free to do that. This last piece is important to focus on as well. So Act 120 prohibits, on July 1st, 2016, prohibits food offered for retail sale. Sold is just shorthand, but offered for retail sale. Well, as it turns out, manufacturers, and I think we could all think about this, manufacturers don't control when a food is offered for retail sale. A retailer does. So in recognition of that fact, the Attorney General said right up front, we've been pushing this process as quickly as we reasonably can so that manufacturers are going to have a year lead time, ideally, maybe more, to know what these labels look like. But it's possible that some stock will take longer than that to rotate through the shelves. So what the rule is proposing is that manufacturer liability is limited. What it really says is they're presumed to have complied with the law up until July 1st, 2017. So if you come upon a product in the store... January, thank you. January 1st, 2017, not a year, 6 months. If you come upon a product in the store that is mislabeled in October of 2016, we presume that it was actually properly labeled before July 1, 2016. But we can imagine circumstances in which we know that that chocolate milk in December of 2016, well, if it's not properly labeled, something bad happened or is about to happen when you open it, right? So there are going to be certain products where that presumption doesn't work. But for those 6 months, they're going to be presumed to be compliant. That doesn't mean that they can't be investigated, but it does mean that that's the presumption. It'll take that long for that stock to rotate through. Tail end. The Attorney General talked about this briefly, but this is the expected timeline. This summer, we solicited through a questionnaire some input. We're now doing some public meetings to gather feedback in an informal setting. Within the next couple months, early next year, tail end of this year, we plan on submitting the rule for formal legislative approval. That's the formal rulemaking process. During that formal rulemaking process, there's an opportunity for formal comments. What you tell us now is sort of on an informal level. We're going to listen and incorporate as best we can. But the formal comment period follows a much more strict legal timeline. Again, the anticipated release date is in July 2015. Anticipated final approval. And then shortly thereafter, we anticipate issuing a guidance document that also explains how we interpret the rule and how we will set our enforcement priorities under the rule. This is not a binding law like the rule is, but it clarifies the Attorney General's position on it. Finally, July 2016, the law and the rule take effect. So now we're ready for questions and comments if folks have them. Again, it'd be great to just get questions first. I'm happy to answer what I can. We can have a little bit of a dialogue, and then if there are folks who have sort of a formal comment they want to make, we'll save that for the very end. Here's some information if you want to write down. You don't think of a question today, but you have one later. You don't think of a comment today, or you don't want to make it publicly, that's fine. In this forum, you can submit it either through our website, or here's the email address down at the bottom. I'm going to check that regularly. So let me just open up the floor. I should also say this presentation will be available on our website next week. This being the last meeting, so I think we've got it. Go ahead.
How will the rule be enforced, or the law be enforced?
So our office, through the Consumer Protection Division, will be responsible for enforcing the law, but there's also provision in the law enabling a consumer to bring action. So it'll be through the courts, to the degree that we need to go to court. I mean, a lot of these cases settle once they recognize their liability.
I'm still having a little trouble wrapping my head around meat.
Yes.
Because I don't understand exactly what the FDA labeling is. So is there a way that we will know whether, the beef or chicken, whatever I'm buying, whether that animal has been fed genetically grown corn or whatever?
Not under Act 120. As I understand it, the legislature's intent there was an understanding, and I think this example was used a bunch, and I just like it, in part because I like Fritos. But just because I eat Fritos, which I presume are, I don't know, but I presume are produced with GE corn, doesn't make me genetically engineered. And that is the same thought process for exempting animals and animal products, unless they themselves are genetically engineered. Those would be required to be labeled. I didn't touch on that because there actually isn't a commercially available meat product yet. There's a salmon in production, but does that make sense? I recognize you may not agree with it, but that's at least my understanding. Other questions? Yes?
Hello. I'm a producer of candy, and I understand for each ingredient I'll need to get the sworn statement whether the food is knowingly or unintentionally produced with GE. However, it has to be a special form from you guys, and you don't have the form ready yet. And I'm already having to order boxes, which are going to in quantity, so that they'll last beyond the 2016 date, which makes a problem for me.
I understand that concern. So let me say two things. One, the proposed rule doesn't require any specific form. It just says a sworn statement or affidavit. Two, the proposed rule has appended to it a proposed form affidavit. So I don't know if folks have printed out the rule. I got a copy over here, but if you go to our website and you click this link, you can look at the proposed rule, and at the very end is this form, which is the form affidavit that could be used in that circumstance. Yeah. At least I should say, at this point of the proposed rule process, we don't anticipate requiring a form or requiring a form different than this one. So I think you'd be safe using
Okay,
this.
and then I have to keep that form for 3 years, and then I'll have to have them fill it out again. Is that right?
Anytime you purchased new product, you would need a new form, right? I mean, unless, because every lot of sugar could be from a different manufacturer or come through a different supply chain. Some could be beet sugar, some could be sugar cane.
Also, every time I purchase it, I'll need another form.
You'll need something to be a sworn statement. It doesn't have to be that form, but it has to comply with the requirements of a sworn statement that the food was not knowingly or intentionally produced. And again, the rule lays out the specific requirements for that form, but they're actually fairly minimal. The form affidavit is just exactly that, a possible form you could use.
I was, when you were talking about retail unpackaged, like restaurants, and then you were talking about the proportion of which could be sold to eat there or to take away.
Sure.
It's a very interesting question for the Golden Arches and people like that. Because I would assume that for most of the big fast food places, a larger proportion than 50% is taken away. So does that mean that they're covered by Act 120?
I apologize if I was unclear on that. So a place that is a restaurant all of their sales are going to be, don't require labeling. It's only in circumstances where you may have, because all of their meals, regardless if it's carry out or not, and I didn't mean to make that distinction, it's all prepared and intended for immediate human consumption, and it's all a taxable meal under Vermont tax law. So where you eat doesn't matter. It's more in circumstances where we make sandwiches in the back, we sell some bread here, we have some fresh produce, and some canned goods as well. And actually, the deli is the thing that makes
So even if it's entirely takeout, it's still viewed as a restaurant?
Yes. Or they're taxable meals, and that's what makes the distinction.
Okay, so I guess I'm just trying to clarify on that a little bit more myself. So something like a gas station that has a store where they have part of it where they sell pizza and they got a Dunkin' Donuts in there and stuff, and the other half is stuff that's processed grocery store stuff. So can you just clarify for me just
Sure.
again, it's 50%, but is it the 50% takeaway or the 50%, where does?
Before I even get to that,
Okay.
it only applies to unpackaged foods.
Okay.
So all those canned goods and soda and crackers, those are
Gotcha.
packaged
Okay.
processed foods.
Okay.
They're still in. It's when the immediate human consumption, the taxable meals, are more than 50% of their gross food receipts. So their gas doesn't count.
Right.
But all the grocery items, along with the pizza, along with whatever else, they already make a distinction between their taxable meals and their grocery items because they're taxed differently. That's the ratio. And again, the goal there was they're doing the calculation anyway. This is a simple way for them to figure out labeling as a retailer.
So Todd, if a convenience store sells gasoline and all the others sells bananas that are not packaged, if they were GE bananas, they would not need to be, there wouldn't need to be a sign at the bin there if they met the 50% threshold for the taxable meal?
Yes. Yes. Yeah.
Can you tell me the reasoning behind labeling the whole box produced with genetic engineering rather than individual ingredients?
I can tell you the thought process in the Attorney General's office, but I think it probably mirrors the legislative thought process. Specific ingredients, the goal is to provide consumers and the public with the information that with accurate information that they're interested in having, that they want in order to make a purchasing decision. And whether that's specifically tied to an ingredient or not, I believe a manufacturer could make that distinction. A manufacturer could choose to put the asterisk on each individual ingredient. The law doesn't require that. Part of that is because federal law controls the ingredients. Federal law controls the nutrition facts panel. State law doesn't reach into that. But what state law can say is disclose this accurate information on the package. And so what we're recommending in the rule is that's a compliant place to put it on that panel. You could put it somewhere else, but it may not be compliant. And it certainly doesn't say it's got to be flagging these specific ingredients.
Let's say an item has one ingredient, canola oil that's genetically engineered, from a genetically engineered source. Could the manufacturer put an asterisk next to the canola oil and just underneath there say, produced with genetic engineering? That would let the public know that those other ingredients supposedly aren't. Would that still satisfy the rules?
Yes. What the rule says is the disclosure has to be on the box, and it's safe right there. An asterisk before highlighting a specific ingredient, the rule and the law don't mandate it, but they don't prohibit it either.
And the font size has to be at least the same size as the, serving
The
portion.
federal mandates have rules for font size as well, right?
Yeah.
This would not conflict with any of those?
No, in fact, sorry, that's the one I wanted.
Or kind of go along with their laws?
Again, the thought process is a manufacturer has to make that calculation under federal law. They know what size the font is going to be for serving size. They're just putting it on the package. this, just in case people are interested, we threw the term clear and conspicuous around a bunch. This is how it's defined. That is not, clear and conspicuous doesn't apply to the boxes. Doesn't apply to packaged processed food. Again, that's the easily read and easily found. And I can jump ahead to that definition, but it's really long. So I don't want to tire people out with it. I'll just leave it up there if folks want to look at it. Are there other questions? And again, the whole rule, you can sit down, really settle in tonight, maybe around 8:30.
With our Fritos.
Exactly. Or not. Do you have another question?
If a manufacturer chooses to label in the ingredients list of the words natural sugar, naturally produced sugar, would that satisfy the rule now, the way it's situated? In the ingredients list.
Nothing in the rule or the law require, I'm not certain. Are you asking about the prohibition on using the term natural if there are GE ingredients? Specifically, the prohibition does not apply to the ingredients list, does not apply to statements.
So they could do that and still satisfy?
They could. I mean, part of the reason is that natural flavors, natural seasonings, those are terms defined by federal law. And the goal of the state law is not to alter those federal definitions. It's to prevent consumer deception that happens when people see the term natural but don't understand that the actual product has GE in it. Other questions? Yes, sir.
What's the status of the litigation?
I'm on the implementation team, so I stay a little bit away from.
I can speak to that briefly. We filed in early August. The complaint came in July, I believe. Rather than answer the complaint in early August, we filed a lengthy 50-plus page motion to dismiss each and every count in the complaint. The plaintiffs responded with a filing to our motion. We now have an opportunity to file one response to their response, and that should be happening within the next few weeks. We also, at the time that we filed the motion to dismiss, asked that the court set the motion for oral argument, so not just to rule on the written submissions from both sides. Our hope is that the court will go along with scheduling oral argument on the motion, and we hope the oral argument is in November, maybe December, at which time the court will take the motion to dismiss under advisement, and the court will decide when it rules on that. I should also say that both sides, plaintiffs and the state, have articulated to the court, and the court was very much in agreement that everyone wishes to sort of expedite the litigation. And we're here in Brattleboro, so if you look at the Entergy suit, that was a case that was put on a very fast track for decision by the court. Now, that being said, what we don't want, at least at the trial level, to be 3 years down the road and not have had the trial. If there are appeals either to the Intermediate Federal Appeals Court in New York City and then possibly further to the U.S. Supreme Court, it could be quite a while for litigation. Even on a fast track with a case of this complexity and magnitude, I would be very surprised if it's ready for trial before a year from now, or a little bit, even a little bit longer, depending on how long the court takes with the motion to dismiss on the individual counts, what counts are left, what discovery is reasonably available to each side relevant to the counts that remain. But again, the plaintiffs are not wanting, going into the slow mode, and we certainly, as you can see with how we're trying to expedite the rulemaking process, are really trying to move the equation. And I will say that you can also, not only for the information about the rule, look at our AG website, but if we don't have it already, we are soon going to, we have links to all of the court filings so far. We will continue to do that, but we will also have there a sort of a calendar of what's next, so anybody who's interested in the timing of at least what's on the immediate horizon will be able to see that.
Can I ask one more question just on that? Yeah, the issue of the lawsuit. If, for instance, Colorado or Washington, who have initiatives going now, should indeed pass laws, does that help Vermont in any way by saying, because there's the American Grocery Association, basically there's no precedent kind of thing, but does that aid Vermont in any way for other states to have laws that can back up the?
Well, there are 2 states that do have laws. They don't have effective dates because it's both of those statutes require a number of other states, and at least in the Connecticut, I think 20 million population in the
Then an adjoining state.
Yeah.
So probably have to be Massachusetts.
And so I'm just not going to comment on whether other states enacting statutes would be helpful or harmful. Clearly, we will be arguing that this isn't Vermont just going off on a tangent on its own, given the fact that over 60 countries in the world have labeling obligations. So it's not like we're the lone island, on this issue.
When I read through these sample labels, I started at the top and then finally I got down at the bottom, produced with genetic engineering. And I noticed that other things like fat and cholesterol are bolded, but produced with genetic engineering is not in bold. Is there a reason for that? Is there something that prohibits that?
It certainly could be. Again, this is the minimum requirement. What you see here is compliant at sort of a minimal level. What we drew from was the fact that with produce, the legislature required it to be clear and conspicuous. And I flashed that definition up a minute ago, but clear and conspicuous means readily noticed and understood. It's a lot more like, whoa, what's that? That's not what was required for processed food. And again, if the point is, you can imagine it's a different context. If I'm in a store shopping and I see the object, I'm interacting with produce on a different level than I do with a box of cereal. But there's a lot more disclosure with a box of cereal than there is with produce. And so if I'm interested in getting accurate information at the point that I'm making a decision, I'm going to look for it. And as long as it's easily found and easily read, that's going to be sufficient under the rule. So could it be bold? Sure, a manufacturer could make it bold. They could put asterisks on it. But to be minimally compliant, it's got to be, I can glance at the box, I can look for it and find it and read it.
I think the point is that it probably should be bold, because the reason that fat and stuff like that are bold-faced is because those are viewed as something the consumer would be likely to be looking for and really wants to find. And I think this, in other words, if you're looking for recommendations, I would go along with whoever that was.
Yeah.
I would say that it should be
It
bold.
should be bold. Okay.
Maybe not a different point size, but bold.
But bold. Okay.
I'm not clear whether this law will go forward during the challenge by the Grocery Manufacturers Association. Will this continue? That court case might take years.
It's possible. The only thing I can say to that is there's been a motion filed to halt the rulemaking process, and the court would have to consider that once it's fully briefed.
And the question of whether there would be injunctive relief on the operation of the statute itself might well be an issue that the court will need to resolve. The rulemaking process in and of itself does not, if the statute is enjoined from being enforced, then even if we have the rule in final form, it won't have any real impact. And so that issue of whether enforcement of the statute will be enjoined, at least until there's a decision by the trial court, even if that comes after July 1 of 2016, that'll get worked out in the court. But it's has not been resolved right now. The court hasn't ruled on any issue relating to injunctive relief.
Restaurants are basically exempt, it sounds like, sort of.
For unpackaged foods.
Okay, so.
They have a pie.
Right, sure. Now, in a restaurant situation where, say, the proprietor can say, we have nothing but organic products here, or locally grown products. And if that's not necessarily true, is there any sort of repercussions for that? Or is there something that limits them from making false statements?
Yes, though it's not Act 120.
Just our traditional Consumer Protection Act, which prohibits unfair and deceptive acts or practices in commerce, for a restaurant to say all of our ingredients are locally grown or they're all organic or whatever. If that's not the case, quite apart from the GE labeling law, they would be subject to an enforcement action.
And nothing in the law, specifically nothing in the law or rule, changes the scope and reach of that act, or really any other branch of the law.
Thanks.
And this is actually a good example of rulemaking. We had an issue a number of years ago of questions about the signage or marketing saying locally grown, what that means, and what our own means. And what happened was there was a grocery store chain that was saying locally grown, and a Vermont farmer was saying, there's no way that this is grown here anywhere near close. And I forget which chain it was, but when we inquired of them, they said, well, we're a big chain. We got stores all over the eastern United States, and it's locally grown somewhere near one of our stores, and it's just in our... And so we went through a rulemaking process where was clear definitional terms of if it's locally grown, I think it's got to be grown within a 20-mile radius, I think, of the store. I might be wrong on the 20. And obviously, native means it's got to be within Vermont. Our own means that the farm is owned by the... But that's an example of where rulemaking sort of gave more... it took the bare statute and sort of gave it some about unfair and deceptive acts and practices, and gave definition in that particular area.
Just a point of clarification, you mentioned that the court would make the decision whether this law is going to be implemented.
Whether enforcement of the law would be enjoined.
Okay, enforcement. When you say the court, I'm not a lawyer, but what does that mean when the court is going to make that decision?
What does it mean?
Yeah.
One
judge?
At the trial level, it would be one judge. Once the case moves to an appeals level, then it's up to the appeals court to make that determination. And so, for example, totally switching gears here, there is a Texas legislature has recently enacted a law in the abortion arena that basically requires that women's health clinics where abortions are performed meet all the criteria for a certain level of operating hospital. And bottom line is that that law is going to, once it's effective, is going to, will require the closure of many, many abortion clinics in the state of Texas. The federal, at the trial level, the U.S. District Court judge struck down the statute as being unconstitutional. The case was appealed to the Intermediate Appeals Court that encompasses Texas, and the Intermediate Appeals Court ruled that the statute may be enforced while it's on appeal. Those in opposition to the law appealed that question to the U.S. Supreme Court, and the U.S. Supreme Court just reversed the appeals court. So the statute is not going to be enforced while it's at least the intermediate appeals court level. Now, depending on what the Intermediate Appeals Court does with the case, it could go back to the Supreme Court both on the injunctive piece and obviously just an appeal on the merits. So it really depends on what level you're at, but right now the U.S. District Court judge alone will make that decision on whether an injunction is going to be issued. Yes.
What does enjoined actually mean?
It basically is an order that says you may not.
Stopped.
Yeah.
Civics and labeling. My favorite. Any other questions? We're going to open the floor to comments if folks have specific statements they want to give, or again, we're happy to take them at the email address, or if you want to sign up. Yeah?
I have a comment for the woman who asked about meat earlier. That was you. And this is only my opinion, so don't take it for whatever. But the majority of corn in this country is genetically engineered. The animals are fed that. I know in Canada they did a study. They found 93% of pregnant women in Canada have the Bt bacteria from the genetically engineered corn in their bloodstream and in the blood of their fetuses. Institute of Responsible Technology has found that it survives eating and processing and stuff like that, this bacteria. So if your meat is not labeled, you pretty much have to assume it's been fed commercial feed and probably has the Bt bacteria in it. And so you have to make your own choice on that. That they're not labeling it, it doesn't make you, as he said, it doesn't make, from him eating Fritos doesn't make him GE, but it certainly introduces GE components into your system, which your body then has to deal with. So again, that's strictly my opinion. I'm thinking if you're doing meat, it would need to be 100% organic or grass-fed to completely be sure that you're not getting that. So.
But again, the legislature made the decision.
Right.
And I don't want to speak for the legislature, but at least one consideration by the legislature was that in the meat, poultry, and dairy arena, there is much federal regulation, and an issue when state statutes are attacked is whether this is an area that's been preempted or sort of totally controlled or largely controlled by the federal government. And we see that, and I believe this was an effort by the legislature to make a preemption argument less likely to be successful.
But as Todd said pretty early on, anybody can label anything that's accurate. So if it's organic,
Right.
that's totally free. There's no
Grass-fed,
prohibition
they
here.
do.
I came in late, so I'm not sure whether you covered this, but there's a lot of, I have a lot of food sensitivities, and there's a lot of people that do have food sensitivities. And I don't happen to have the kind of food sensitivities where it becomes life-threatening. It's just a lot of nuisance, physiological things that happen. But there are people that have real life-threatening food sensitivities, and while a lot of GMO foods are the ones that have the pesticides built into them, but there's also the GMO foods where they've taken genetics from a totally different food and put it into another food. So one vegetable might have peanut matter, and what have you built in? What have you built into this labeling rule that sort of takes that into account?
Beyond the requirement that it states that it's produced with genetic engineering, again, it doesn't specifically doesn't require a manufacturer to refer to a specific ingredient or disclose what specific genetic materials were mixed together. What I don't know in the context of allergens is what the requirements are for listing potential allergens in a product under federal law. They're fairly prescriptive. I mean, they require certain statements to be made if there are trace elements of tree nuts and shellfish and other known allergens, or the facility contains those items. Act 120 doesn't touch upon those specifics, but it does give that information to people who are interested in getting it.
That's a really good question.
Thank you. I'm Representative Carolyn Partridge. I'm actually the chair of the committee that worked on this in 2012 and 2013. I just want to add to what this lady said over here regarding BT. Those studies were done in Quebec, and it's, I think, unclear why BT is in pregnant women, in cord blood of infants. I don't know that they can attribute it to the consumption of meat, but potentially its presence in the atmosphere, because once corn is chopped and put into the earth, there's BT in every single cell of that corn plant. So I think that that's a little bit unclear, but the Attorney General and Wendy are correct in that we did hold meat out of it because of the potential for exemption, or preemption, I should say. The other thing that I heard yesterday, actually, I don't know how many of you listened to Fresh Air on NPR, but Terry Gross had a piece yesterday on meat and the preparation of meat, and she asked the question of the test kitchen people, if for instance cattle eat products, that grain or whatever that has gluten in it, does it then make the animal, does the animal then become, glutinous? And the answer is no. And that was part of our reasoning as well. We consider animals sort of a biofilter. Just because they eat the grain that's genetically engineered doesn't make them genetically engineered, and I think the Attorney General said that earlier as well, so to be clear.
Yeah, I think the live activity is a little bit different from gluten, but I think what this lady said, I think the point was, at least in my opinion, to err on the side of caution. If you're concerned about that, there is some evidence to suggest that it can be transferred through meat, eggs, milk. So
Potentially, but I don't think that you can make statements.
I'm saying it's suggesting.
Yeah.
There is evidence to suggest that's all.
So, my recommendation, if you don't want to consume that you look for grass-fed or organic, certified organic meat.
You mentioned salmon briefly. Not yet really out on the market as genetically modified, but if that happens, how will the rule apply to that?
So Act 120 actually would apply directly to it. The animal product exemption only applies if the animal has consumed or been injected with a GE material, not if the animal itself is the product of genetic engineering. So if they've altered the genes in a salmon to bring in genetic traits from another taxonomic group, again, overcoming those natural barriers, the salmon is GE, the salmon has to be labeled. It's only when the animal has consumed GE material that it remains exempt. Does that help a little bit? Yes, Karen.
Or Bill, hasn't Alaska passed a law that will require genetically engineered salmon to be labeled?
Yeah, 7 years ago.
Were they sued?
It hasn't taken effect yet.
Oh, because it
it's-
hasn't been released into the
the-
public.
Right, the salmon doesn't exist, so
Oh, okay.
the law isn't operative until salmon. That's mine, I mean, I'm not suing, but,
Why are they on the label changing the mosquitoes if they want to be used to the?
right, the terminators. Well, thank you all so much.